क्या चाहती है इस विषय पर मैं राय रखूं। लेकिन आपसे मैं एक अनुरोध जरूर करूंगा कि आप आए हैं तो जरा जनता से बात करिए और जनता की क्या राय है ये देश को जरूर बताइए।
Good evening. 10 years after the brutal rape and murder of Nirbhaya, two shocking cases have come to light. In Hyderabad, a 4-year-old girl child was raped, and that too by the driver of her school principal. Both the driver and the principal have been arrested. Here in the Delhi NCR region, a 40-year-old woman was gang raped by 5 men. The message is simple: whether you're 4 or whether you're 40, if you're a woman in this country, there is no guarantee of your safety. What has changed in the 10 years since Nirbhaya? But first, let's play out the story of what happened in Hyderabad as well as what happened here in the National Capital Region, and then we'll go across to our guests.
Furious parents thrashing a man accused of raping their 4-year-old daughter. The accused, who was the driver of the kindergarten principal, had been allegedly sexually assaulting the child for the last 2 months in Hyderabad's upscale Banjara Hills. The matter came to the fore after the girl's parents noticed a change in her behavior. She was unusually quiet, appeared depressed, and was often found crying. Finally, she admitted to her mother about the assault. She was allegedly raped in a lab opposite the principal's office. When she went to school with her parents, she pointed towards the driver. The parents then filed a complaint and the driver was arrested. The accused, Rajni Kumar, used to do odd jobs at the school like maintaining the labs and running errands for the staff. According to the police, that's how he came in contact with the victim. Police are now verifying if he harassed or abused other students. Outraged parents thronged the school premises to protest, prompting the school administration to declare holiday. As if the Hyderabad case is not spine-chilling enough, a 36-year-old woman from Delhi was allegedly gang raped and tortured by a group of men in Uttar Pradesh's Ghaziabad and then left on the roadside.
इतना घिनौना केस है ये केस, बिल्कुल निर्भया जैसा केस है। और इस केस में तो कम से कम मेरी सिस्टम से अपील है कि तुरंत फास्ट ट्रैक कराया जाए और तुरंत इन आदमियों को सख्त से सख्त सजा दी जाए।
It's been nearly 10 years since the Nirbhaya case shook the nation's conscience. But has anything changed on the ground in India? Is it still no country for women?
All right, has anything changed in the 10 years since Nirbhaya? Let me now go across to our guests who are joining us. Binay Kumar Singh is an author and columnist. Bachu Srinivas of the TRS party will be joining us. Yogita Bayana is a women's rights activist. And Nirmal Kaur is a former IPS officer. Nirmal Kaur, let me start with you first, ma'am. As a former IPS officer and as a woman, these are the statistics from the NCRB. In 2011-12, the number of rapes in India was 24,270. In 2021, it's jumped to 31,677. A 30% rise in the number of rape cases in India over the last 10 years. Now, normally, whether it is cops or politicians, they will say, oh, that's because the reporting has gone up. Number of women who are coming forth to report these cases has gone up. But surely there can't be a 30% rise in heinous crimes against women over the last 10 years. That prompts us to ask the question, what has changed in the aftermath of Nirbhaya? What has changed in the last 10 years?
I think it is the women's security issues, though after Nirbhaya people have become very conscious and society is trying to do its best, the police, the civil society, everyone together. But still I think the issue of women's security is not properly been addressed. You know, girls are still being raped, a small child, you know, is being raped, a 4-year-old, and then this 36-year-old, you know, which is for some kind of a revenge on her family. You know, women are also used as vessels of revenge. You know, if you want to take something out of a family, you rape the woman of the house, that kind of a thing, you know, they are still considered that kind of, you know, status symbols, you know, that ravishing them is going to give them some brownie points in their, you know, they had some property dispute in this Ghaziabad case.
Yeah.
And to set the scores right, they are going and mass raping this woman who was known to, I think she was known to at least 2 of the rapists. And then she's, So women's security is something which we have to seriously think about, and also perhaps society is not that society is not that conscious, and even women themselves, they go out with people without knowing. I mean, they trust them. I mean, often the rapes are by trusted people only, or by someone in the environment. But I think still this kind of feeling of insecurity, or using women as a weapon to take revenge out of the family, this kind of mindset has to change. This is certainly a very patriarchal.
Let me ask
kind
Bachu
of thing.
Srinivas, in the Hyderabad case, yes, of course, both the driver and the principal have been arrested. But the larger question that's being asked, Bachu Srinivas, is yes, post Nirbhaya, 10 years ago, the rape laws were strengthened. There is now the death penalty for those who are accused of heinous crimes against women. Why is it that we've not been able to stem this culture of violence against women? In the Hyderabad case, it was a 4-year-old. If a 4-year-old's parents can't send her to school, trusting the school administration, the management, the principal and the principal staff, then what hope do we have?
A very good evening. It is a very sad incident which has happened in Hyderabad or in Ghaziabad, or even in the last 2 months back, which has happened in Delhi, Kiren Rijiju also. The incidents are taking place very brutally, and these things are due to the punishments from the government, either the central government. Even after Nirbhaya, the things are going very badly. Things are happening in the entire state. And there is, even I am also blessed with 2 daughters. Everybody is fearing today by seeing these kind of things. See, after the things are happening, maybe they are punished, or they are going to be whatever the things are happening after the things are happening. But before that, no one should dare to do such kind of things, such punishments as to come in the society. All the governments, whatever the state governments or central government, or whatever the government is there in national government, the constitution, in the constitution, things are has to be amended, where there should be fast track courts. People should fear that to do such kind of things. Even 1 year below babies are raped. Such things we have seen. It is unfortunate and to talk and to hear these things. Very bad things are going in, even in Hyderabad or all over the country. This is happening.
Let me ask Binay Kumar Singh, again, if you look at the NCRB data, in 2011-12, the number of rape cases in Delhi, reported rape cases, was 706. In 2021, it has jumped to 2076. That's a nearly 3-time jump in 9 years. If the fear of law, now like I said, the death penalty is also applicable in the cases of rape. If the fear of law, if strengthened rape laws are not a deterrent, and if the number of cases has jumped up 3-fold in the last 10 years, then what more needs to be done, Binay Kumar Singh?
See, that is what I am telling.
No, Binay Kumar Singh, please. Thank you. Thank you, yeah.
Jaka, rape is one of the most terrible thing which happens on earth. But the most horrible part of that is it happens every day, every hour, somewhere, sometime, somewhere. And the problem is that the groups who are dealing with cases of rape, they are trying to educate women how to defend yourself. The group must try to educate men not to rape. We must educate the source. We must deal with the source. And I think it is the male masculinity superiority complex, which comes with such kind of expression. And I think it's high time to educate men not to rape. It's not only laws, new laws or amended laws which are going to, help. You need to come to the source, the main source, the mindset. That you are trying to settle a property dispute. Somewhere, some state is there where you try to settle your political scores by raping women. This is your kind of superiority. You try to show off that you are superior than a woman by raping her. It's high time, Jaka, that only law is not going to help. You need to tackle the source, you need to deal the source, you need to deal the mindset, you need to deal with the epicenter.
No, but how are you going to change
need
that
to deal with
mindset?
the
And I want to ask
epicenter, Jaga.
Yogita Bayana that, you know, for example, fast-track courts was one of the reasons that was cited after the Nirbhaya case. And even today, in 10 years, there are only 30% rape cases in this country that are being fast-tracked in the sense that you're getting a conviction or a judgment one way or the other within less than a year. The remaining 70% cases are still dragging on, even in the so-called fast-track courts.
So first of all, Zaka, let me thank you for doing such a needed debate or discussion. I would rather put it this way, because it's a discussion and we really need to do this as the topmost priority. You know, there is nothing worse than this. You know, I would rather even put this before the external security, because our own daughters are not safe. We cannot talk about, you know, saving ourselves from Pakistan. Our daughters, every single day we have Nirbhaya-like cases. So thank you for, first of all, discussing this such a sensitive matter. Now coming back, as the earlier panelist, I was, you know, listening him. So basically we need to attack the source and we need to work on the mindset. These are the things can be done. You know, it's not that I, as an individual, as Pari, we are doing it every single day. We are going to village level, talking to boys and men. This is the awareness. We can talk to girls also about telling them about their rights, but and self-defense. What will self-defense do if a girl is, you know, kind of garrotted by 4-5 people? How can she protect herself? No matter, no amount of defense will work there. So we need to work here. We need to work with the men. Now coming back to your very pertaining question, that fast track courts. Yeah. I'm sorry, it's a myth. No fast track exists in our country. Even if we get, like, charge sheet is filed in 6-8 months, FSL report comes, maybe it takes a year. I'm not even talking about the compensation. Then it goes to the higher court. Then it goes to Supreme Court. I've seen so many cases. I have not, in my 10 years of working only on this issue, seen any girl getting justice. Nirbhaya case also, I would not call it justice, because 9 years it took to get them to the gallows. That too after so much of struggle of the mother and the activists. Now, these are the cases which are reported. We are not even talking about the cases. They are 90% or more than 90% of the cases which are not even reported. So we are discussing right now the cases which are reported. Don't, out of that 70% don't even get justice, or they are still in the court. I mean, the conviction rate is 21% something, even for the cases where the charge sheet has been filed.
No, in case of rapes of minors, as has happened in the Hyderabad case, Yogita, the 2021 conviction rate in child rape cases is only 2.3%. 2.3% is the conviction rate for child rape cases in this country. I mean, that's a shame. Total.
We should really, you know, kind of feel ashamed, each one of us, because I mean, we are failing our daughters. Government, all the more reason, but society also, because we have become so immune. I mean, children, I mean, I have dealt maximum POCSO cases in my life, and I can't tell you the plight. I mean, you can't even sleep for nights when you see a child 1 month old or a 6 month old I have held in my hand. So I just don't know what to say. I mean, we can do these discussions till the time we don't have any serious kind of a mission mode situation. We will never be able to cope up with this situation, because I was very positive. Maybe when Nirbhaya happened, that was the blessing in disguise. We felt things will change for betterment. No, but we have seen the reverse.
Kaur, I mean, a lot was hoped after Nirbhaya and the subsequent change of the laws, more stringent punishment, the death penalty. Now for rape of a minor below 12 years of age, there is the death penalty as well. In 2021, there were 3,000 child rape cases reported in India. 3,000. I mean, it's unacceptable that in a country like ours, 3,000 young girls are being heinously assaulted in one form or another every single year. And the fear of death is not stopping this, or is not reducing this number.
I think we need to sensitize men and adolescents and boys, and, you know, because this is, after Nirbhaya, a lot of attention has gone on to this. But, you know, this prevailing pedophilia, the porn on the net, I mean, those cases are so high, and those are kind of high stimulants for this kind of behavior. So maybe we need to control, you know, the roots of this kind of behavior, because all you see is the outer manifestation, but we are not going behind and finding out what the cause is and addressing that. And the child, because children are not able to give evidence, and our courts so insist on evidence. They are so bound by this copybook kind of, that presumption that let 999 guilty go unpunished and one innocent should not be punished. This beyond doubt thing, though rules have been changed, presumption of innocence has been changed, but the mindset of the courts remains the same. Even after Nirbhaya case, I remember once there was a seminar and some Supreme Court judge came in some High Court function and he said, oh, everybody is asking for fast trial, but it should not be at the cost of a good trial, a lawful trial. By lawful trial, if you mean that you have to, have all the proof beyond doubt, how is a 3-year, 4-year-old child going to provide it?
Yeah.
I mean, it's an innocent child. You cannot, and they forget, they change, and children can be very capricious. I mean, they cannot be expected to abide by the strict kind of these demands of law. So that's how our conviction rate in children's rape cases is so low.
No,
and even otherwise our record is
Binay Kumar saying, the law, of course, one purpose of the law is that the law acts as a deterrent. But what Yogita said, that even in a high-profile case like Nirbhaya, where people were out on the streets, they were protesting for days and months on end, there was so much media glare, it took a whole decade for that case to reach its logical conclusion. If that is the kind of timeline that our criminal justice system lends itself for such a high-profile case, then again it comes back to the question of what's the point of having fast-track courts? Only 30% cases, at least in the lower courts, are getting some kind of finality within a year.
Yeah, Jaka, I think this is a worse kind of situation and this needs to be dealt with. This needs a solution. If it is fast track court, it needs to be a fast track court, it needs to be a fast track justice delivery system. But again, Jacob, previously if you go down the line 20, 30 years back, you know how the rape cases were dealt in the lower courts. The girl was, surrounded by lawyers, battery of lawyers and many persons surrounding her, and several questions were asked. Nasty kind of questions in open they were asked. How were you raped? What was, I can't explain you that. But I think things have changed and things needs to change more. Even if a single rape case is taking place in the country, it's a matter of shame. And I think it's a failure of, we are not able to sensitize, we are not able to do any kind of precautionary measures. And I agree with Yogita that, okay, law is there, tough laws needs to be there. Okay, the fast track courts need to be more fast. But again, sensitization is also a part. The government, the NGOs, even we in our daily life, we must try to sensitize maximum that about rapes, both the parts, not just women, to the men's also. And I think mostly sensitization is needed in the men.
Bachu Srinivas, one of the critical aspects is about occupying public spaces. We say that in our country, a labor participation rate, the female labor participation rate is so low, it's under 25%. How will any parent send out their children to public places, either for work or for education or for any other reason, if there is the fear that anyone, and it doesn't matter what strata of society you're coming from, you could be rich, you could be poor, anyone faces the threat of their daughters being assaulted in some form or fashion in a public space. I mean, that is, again, a critical aspect. If our public spaces are not free for 50% of the population, or not safe for 50% of the population, then what's the point? What's the point of having free and open societies?
No, from government side, every government is taking care of the women, whatever the precautions has to take. Like our government is taking that she teams and women police station. There are a lot of things, a lot of measures are taking, precautionary measures are taken by the government, and Mufti police are going to take care of the immediate response wherever they are. There some toll-free numbers to whenever they are in risk. But in some cases, now you take this case, 4-year child baby in a school room and in front of the principal's room. how can she protect herself and how can she face him? He's a driver, maybe he's around 25 years old man, and this is very young, 4 years old. So in these cases, in typical cases, these are the typical cases. But from government side, government will give the assurance. But under humanitarian grounds, people are losing the ethics, values, morals, and they are losing what they are doing. They are forgetting what they are doing. This is the problem. It's a problem of the society. It is not the problem of somebody else. So see, one or two cases, whenever it happens, we cannot demoralize the parents or somebody or woman or anybody else. We are here to protect the people. We are take care of the things, and like media, we all the people in the society, whoever plays the vital role, should face it. We have to concentrate on these things. Whatever we can do from our side, we have to do.
I'll give Yogita Bayana the final word. Again, I go back to the number of rape cases. I mean, Hyderabad is generally considered a safer city for women. In 2011, the number of rapes were 59. In 2021, Yogita, the number of rapes has come up to 116. It's almost doubled in the last 10 years. Of course, some part of it is that more and more women who are survivors of sexual assault are now coming forth and reporting those cases. So some part of it is greater reporting. But surely, if the fear of law, death as a deterrent, even fast-track courts are not helping bring down that number, then surely we need to ask ourselves, something is amiss here.
It's more than a miss. I think it's a total failure of the infrastructure of the faith in democracy as women. How do we trust? Like, even if we instill that faith in that woman, come and report the case, we are with you. But when she goes to the police station, she fizzles around because there is nobody who's willing to support her. The kind of training they get, the cops I'm talking about, then she gathers more courage. Okay, no, I have to fight my case. She goes to the court and there she's, moved down again. So there are hurdles after hurdles. I mean, it really needs some kind of a superpower to kind of deal with your own sexual violence case, unless you have support of NGOs like us or activists like us, but we cannot reach out to all. We also are very handful and the cases are like massive. So I'm trying to say that as government, it's their duty to instill that kind of a faith in that woman. Okay, you go report, we are with you. But sir was talking about the previous days, when the girl was used to be surrounded. Even till today, when I go to the court, they are very insensitive. I'm so sorry, but these are the things I wanted to bring up.
But Yogita, I thought after Nirbhaya and after the laws being changed, if a woman goes to a police station and complains of sexual assault, grievous sexual assault, then two things. One, the police have no choice but to register her complaint, to register an FIR. And two, as I understand, a woman police officer has to be present to take down the complaint. Has that not changed?
No. See, there is no SOP followed. I'm telling you because I've seen it firsthand. I'm telling you, they are not followed properly. Maybe in certain cities and all, they are followed. But when you go to interior, because now I've been traveling a lot to Jharkhand and Bihar, I know SOPs are not followed. The insensitive comments, they kill the soul of the survivor. They make comments like, why were you out? Why did you wear this? I mean, these are the comments coming from cops. I can prove you.
Okay.
I mean, I have these things. I have heard these comments myself. And they also raise finger on me that you are a woman. Why are you here? I mean, I can go on and I can write stories. I can share all these anecdotes.
All right. We'll leave it at that. We hopefully that, the more such cruel and gruesome cases come to light, the media spotlight, and of course, we have seen instances in the past as well, where at least some of these cases which have a media spotlight, it has taken a long time, but yes, it has reached a finality. It has reached some form of a conviction. Ultimately, I think I agree with what both Yogita and Vinay Singh said. Yes, you can have the strictest of laws, and you should, for cases against women, for sexual assault against women and grievous sexual assault against women. But ultimately, just having tougher laws alone is not going to cut it. It has to be a mindset change, and that mindset change has to come from the men who are, as Vinay Singh said, the source of all this trouble and all these problems. I'm going to move on here on the show to the other big story. It's a political story, a big day this for the Congress party, which got its first non-Gandhi president in 24 years. Mallikarjun Kharge beat Shashi Tharoor by more than 80% of the votes. Despite his last-minute nomination, Kharge was widely seen as the official candidate, the one who was the blessings of the Gandhis. He has promised reforms, but few are expecting any big changes. Shashi Tharoor built his campaign around change, but before the results, he alleged that some parts of this poll were not above board. There were even allegations of rigging. But nonetheless, just as the results came out, he went to Mr. Kharge's house and congratulated him and promised to work with the new Congress president to usher in reforms in the Congress party.
आजादी के 75 साल के इतिहास में भारतीय राष्ट्रीय कांग्रेस ने लगातार इस देश की डेमोक्रेसी को मजबूत किया और संविधान की रक्षा की। आज जब डेमोक्रेसी खतरे में है, संविधान पर हमला बोला जा रहा है और हर इंस्टीट्यूशन को तोड़ा जा रहा है, तो कांग्रेस पार्टी ने राष्ट्रीय स्तर पर ऑर्गेनाइजेशनल इलेक्शंस करवाकर देश की डेमोक्रेसी को मजबूत करने का एग्जाम्पल पेश किया है। कांग्रेस प्रेसिडेंट के चुनाव के सफल आयोजन के लिए मैं पार्टी के सभी डेलीगेट्स, सीनियर लीडर्स, वर्कर्स और जो कोई भी इस कार्यक्रम से जुड़े हैं, उन सबको मैं धन्यवाद करता हूं।
I want to go across to Pallavi Ghosh, our senior editor, who has been tracking these Congress presidential polls. What is going to be Mr. Kharge's #1 priority? And more importantly, what can he do in the first few days as Congress president-elect to try and at least dent the notion that he is simply a proxy for the Gandhis?
Well, he has to. His priority really is going to be winning elections. Gujarat and Himachal elections are coming up and they haven't chalked out their strategy. So, Zaka, that's going to be his priority, to also show that under his leadership, at least the Congress party can start winning elections. Second, of course, is to keep the flock together. One of the first crises he may have to diffuse and sort out is that of Rajasthan. Whether it's going to be Sachin Pilot who's going to take over, or Ashok Gehlot remains. That's one. To answer your second question, Zaka, well, I mean, Mr. Kharge himself has said it repeatedly. And even when I was at the AICC headquarters through the day, even while they were celebrating the announcement of Mr. Kharge as a Congress president, I did see a lot of posters, lots of slogans talking about Rahul Gandhi Zindabad, Sonia Gandhi Zindabad. So as far as the Gandhi family goes, I don't think their grip on the minds of the Congress leaders is going to go away anywhere. In fact, all the voices I spoke to kept on making the point, and to quote them, the Gandhis are the roots and the tree is the Congress party, and Mr. Kharge is just going to nurture the tree, which just goes on to show there's always going to be this shadow over his working style, and how far is it going to be possible really to take a decision completely on his own and to ensure that he doesn't look across as a remote controlled Congress president.
All right, Pallavi, we'll leave it at that. That, of course, is going to be his big challenge, winning elections and, of course, coming out of the shadow of the Gandhis. But we've got a piece of breaking news, a big one this. Pakistan is finally out of the Financial Action Task Force grey list. Remember, Pakistan had been in the blacklist initially and then moved up to the grey list. From 2018-19 onwards, it had been under the gaze of the Financial Action Task Force. And now, finally, after 4 years, the FATF has released Pakistan out of its grey list. Let me go across to Abhishek Jha, who tracks the MEA for us. Abhishek, what are the reasons for why Pakistan has been let off the hook, as it were?
So clearly, Pakistan was found to have met almost 28 parameters that FATF had given Pakistan to get away from that grey list, and almost 5 to 6 parameters were the assessment that were required. And recently, FATF team has also visited Pakistan to have a first-hand experience and information regarding what all action Pakistan has taken to curb money laundering and terror funding and against individuals. Recently, we have also seen that Pakistan has tried to put a few persons, like Hafiz said, was apparently he was put behind the bars, and it was in a way to showcase Pakistan's tough action against counter-terrorism and money laundering cases. And probably those assessments that FATF was recently in Pakistan to have a first-hand account of have been positive, and probably that has helped Pakistan to get away from the grey list. And this will be a big boost to Pakistan's current government as well, because now Pakistan can have access to international monetary funds, loans, and other international monetary institutions can also help Pakistan, which were until now stopping their help or their extending their loan because of Pakistan being apparently a nation which is not, which was in a grey list for being reasonably being behind those terror funding and terror individuals.
Abhishek, we'll see how this plays out, but it needs to be asked, what meaning does this action have when renowned terrorists, Hafiz Saeed, Masood Azhar, those who are wanted for attacks here in India as well as in other parts of the world, are roaming scot-free in Pakistan? What meaning does it have that the FATF has let Pakistan off the grey list? That's a wrap. Anusha joining you with the biggest exclusive.
Good evening, hello and welcome to the special broadcast. I'm Anusha Soni. The Supreme Court of India is the final arbiter of the Indian Constitution, which means that whenever there's a dispute, it's the top court that decides what the law really says. What did the Constitution makers really envision? This court, on various critical junctures in Indian political history, has protected individual liberty, the rights of its citizens against the might of the state. That being said, the core process of appointment of judges at the Supreme Court and the High Court has been a topic of debate for decades now. The present process of judicial appointment is called opaque and also nepotistic by some critics, including the Law Minister. The other side of the argument is that if executive were given more say, more power in judicial appointments, this will compromise the independence of the Supreme Court, an institution which keeps the government, the elected government of the day, in check. Well, the bottom line is that the members of the bar and bench on either side of the debate agree that there is a need for the system to reform from within. There's a need for reform within the Collegium system. That leads us to some questions. First, should the present Collegium system be made more transparent? Is it fair for the government to demand more say in judicial appointments? Is that healthy for democracy? And what are the dangers of excessive interference by the government and conversely, having no checks and balances in the present Collegium system? We take up these critical issues on Biggest Exclusive tonight.
I, having been appointed a judge of the Supreme Court of India,
I will bear true faith and allegiance to the Constitution of India as by law established.
I will truly and faithfully and to the best of my ability, knowledge and judgment
perform the duties of my office without fear or favor.
I will uphold the Constitution and the law.
Well, discord over the Collegium system and what exactly has the Law Minister said that has led us to the debate that we are having today. Here are some words coming in from Union Law Minister Mr. Kiren Rijiju. He has said it very categorically and emphatically that there is a need for reform. And what is the present Collegium system that the Union Law Minister thinks should be reformed? The Law Minister says that the present Collegium system is an opaque, closed-door system. There are no checks and balances, and we need to ensure that there is some degree of reform that comes. Judges appoint judges. It is famously said, for the judges, of the judges, by the judges. Is that really a proportionate criticism? Many disagree. A group of lawyers have created a monopoly. He said that 40 to 50 lawyers who speak very good English run a courtroom in the Supreme Court. It's hijacked by that courtroom. No other democracy has this system. The Law Minister is right here. Whether it's US, UK, South Africa, there is certain degree of executive role and a larger role that the executive plays than here in India. Appointing judges is the task of the government. The primacy, the question here is of primacy, which means that if the judges of the Supreme Court and the government does not agree, whose word is the last word? Right now, it's the Collegium's word, which is the last word. People don't know the politics within judiciary. Wherever there is power, wherever there is concentration of power, you are likely to have politics in that institution. That's what the Law Minister is also talking about, that you know about politics that happens in political parties, but you don't know what happens in Supreme Court. Let's now move on and tell you what this Collegium system is about. Collegium has no mention in Indian Constitution. That word you will not find in those two articles which define the Supreme Court and the High Court of the country. Appointments and transfers of Supreme Court and the High Court judges is taken up by the Collegium system. Collegium consists of the Chief Justice of India and 4 other topmost judges of the Supreme Court. As I said, it's a 5-member body headed by the Chief Justice of India, and that's what the body is. At the High Court, there's also a system led by the Chief Justice and 2 more senior-most judges, which makes recommendation. Government receives the names decided by the Collegium. They give their opinion. There's an IB report, which is given back to the Supreme Court if the government disagrees. Power to veto, and the final word is with the Supreme Court Collegium. Very briefly, the entire legal history of the first judges, second judges, third judges and the NJC judgment is about who has the last word. You'd be surprised there was a point in Indian legal history where the executive or the government had the final word, and that is why you had the emergency and supersession. System not rooted in the Constitution. As I said, the word Collegium does not exist. That being said, 9 judges of the Supreme Court handed out a judgment and said in SP Gupta versus Union of India that there is a primacy of the Chief Justice of India. There is no specific law promulgated by the Parliament. There is no article in the Indian Constitution which directly talks about the Collegium system. The system has evolved through the Supreme Court judges and its judgments. As I said, the first judges, second judges, third judges case and how the position has been in the NJC. It is clearly something which has been a making of the Supreme Court of India. Well, decoding this for you and talking about what this entire debate is, what are the points, what are the issues on both the sides. The central government takes a jibe at the Collegium, and this has not happened for the first time. In the history of last 10 to 15 years, even in the Modi government, present Modi government, we have seen on many occasions where the government and the Supreme Court Collegium has locked horns. SC struck down laws on NJC formation. This was a law that was ratified by 16 state governments given assent by the President of India, struck down by Supreme Court. The government has undermined judicial independence. Why was NJC struck down? Because it violated the basic structure of the Constitution according to the 4 judges of the Supreme Court who was sitting on that bench, the 5-judge Constitution bench. Those are the 2 points that we're talking about. Those are the 2 sides of the debate. Well, let's also get you the people who really matter in this debate. Joining us on the broadcast is Justice Madan B. Lokur. He was one of the 5 judges who was on the Constitution bench, which had struck down the NJC, terming the law as violative of the basic structure of Constitution. Sir, thank you so much. It's always a pleasure to have you on the show. My first question to you is about what the Law Minister has said. The Law Minister terms the present Collegium system as an opaque one. He's also severely criticized the manner in which a certain coterie of lawyers is running the Supreme Court of India. Your thoughts?
Well, the Law Minister is right that nowhere in the world judges appoint judges. Even in India, they do not appoint judges. Even in India, judges do not appoint judges. It is the President of India who appoints judges. And the appointment is done by the President through the Government of India. So the canard that is being spread that judges in India appoint judges is absolutely incorrect, right? And even the previous Chief Justice of India, Justice Ramanna, had said that judges do not appoint judges. I mean, if somebody has a perception, well, good luck.
Well,
this can be said about any court, that persons who have good Hindi or who know good regional language, they are running the courts. Well, that's a perception that anybody has.
Well, sir, to bring to you the other side of the debate, to be the devil's advocate here, Collegium is being criticized for extra-constitutional because nowhere in the Constitution do we have the word Collegium. It is being argued that the system was alien to the original structure of the Indian Constitution. Please respond to that argument.
Well, 9 judges of the Supreme Court have said that there should be a collegium system. So I really don't see, what the debate is all about. Yes, there has to be some changes. I will not say reform, but there will have to be some changes that should be made in the collegium system. There is a memorandum of procedure that can be tightened up.
Yeah.
The government is doing whatever it wants to do with regard to appointments. For example, it is sitting on the files of persons who have been recommended by the Collegium for months together, for years together. So I think the power of the central government to, dictate terms to the Collegium needs to be curbed. I mean, the government can't, unless it has no respect for the judiciary, if it has no respect for the judges, then perhaps it's a different matter altogether. But if it has respect for the judges, then I think it should accept the recommendations made by the Collegium.
So the argument here is you're saying that this is not a system where judges are appointing judges. But the argument is that executive should have more say. They should have the last word because that is how the constitution makers had actually envisioned the process to be. What do you say about that?
Well, the executive does have say, isn't it? That's why they're holding up appointments. If the executive did not have any say in the appointment process, they could not have held up the appointments of judges for months together and for years together. Obviously, they have a say. But their say must be reasonable. It can't be that, I will not appoint or I will not hear a recommendation made by the Collegium for years together. Their appointments have been delayed by 3 years in some cases, by 2 years in some cases. Recently, one candidate got fed up and he withdrew the consent. So how can anybody say that the executive doesn't have say? It has a say, and in fact, I think it has too much of a say. That has to be curbed. That is why I think the executive must respect the judiciary and must give the due respect to the judiciary. It is not that the judiciary is always right, but it is also not that the judiciary is so wrong that the government holds up the appointment for 2 or 3 years. It can't be like that.
No, sir, with due respect to you, and you're also saying that judges can also be wrong. But where is the mechanism for checks and balances if judges go wrong? That mechanism has to exist within the elected government of the day. That's the argument.
Yes, judges can be wrong. I'm not saying they can't be wrong. So if the Collegium recommends a person for appointment and the government feels that there is something, amiss, at the time of sending the file to the Collegium, it should make its views clear. Why should it make its views clear after the recommendation is made by the Collegium? Why can't they send it before? Instead of just, acting as the post office and sending the file, give the comments and say that, well, this candidate has been, this person has been recommended by the High Court. And, we feel that he should not be appointed and these are our views. Let the Supreme Court take a call on that. But what is happening now is that the government, after the recommendation is made, the government says, no, we will stop that appointment. I mean, what is it? Except trying to, humiliate the Collegium by doing this. And should the government be allowed to humiliate the Collegium? The Chief Justice of India and the 4 senior most judges? Should the government be allowed to humiliate? That's the question.
Well, that's some strong views expressed by Justice Madan B. Lokur. Sir, thank you so much for giving us your time and joining us on the broadcast. Well, from that one voice, we move to another voice. Dr. Ashwini Kumar, the former law minister, a senior advocate, is also joining us on the broadcast. Dr. Ashwini Kumar, thank you so much for speaking to us. I would take the same questions to you. We had Justice Lokur with us on the broadcast some time ago, and he responded to what the law minister has said. Your thoughts on what the law minister has said, because you've been in those shoes earlier. Do you agree with Mr. Rijiju?
Well, there's a very wide political consensus in the country that this system of judicial appointments through the Collegium has no basis in the Constitution. This is the view that we in the UPA had also taken, and that is why we had proposed a tweaking of the Collegium system by including the law minister in it and some other experts in it. For some reason, the Supreme Court, even after the Parliament had passed the Constitution amendment by the requisite majority, chose to strike it down. So there's a very wide body of informed opinion in the country that believes that this was wrong in striking down the law proposed by Parliament. I personally believe that the Supreme Court went wrong in equating judicial independence with the mode of court judges. Please do not forget that the court decided to establish the Collegium system. All judicial appointments were done by the government alone. And some of the most outstanding, fearless and independent judges and men of great merit were appointed at that time by the government alone.
Well, sir, the NJC, as you said, was struck down by the Supreme Court Constitution Bench 4:1. But in that judgment as well, there is a recognition for the need of reform within the present system. What can that reform really be?
The issue of the MOP is still pending, and I'm sure that the Law Minister and the Supreme Court will find a modus vivendi. But the fact remains that the central issue in this entire debate is whether the word consultation in the relevant provisions of the Constitution should be read as concurrence. The Supreme Court has so read it on the basis that independence of the judiciary being a part of the basic structure of the Constitution, all procedural requirements must conform to that overarching objective, and have therefore gone on to conclude, in my view, erroneously, that only if the judges in the Collegium appoint judges can we be sure of independent judges being appointed. I don't believe that is a correct premise at all. So therefore, taking the NJAC judgment forward is one part of it, which of course is a decision that will have to be taken, and the sooner it is taken, the better it is. But the fact remains that a lot of recent judicial appointments have come into controversy, and for good reason. Therefore, I find nothing objectionable in the Law Minister expressing his views. After all, he's a key functionary in the whole process.
Well, sir, there's also a trust deficit between the elected government of the day and the Supreme Court Collegium, and it is not very recent. The need for reform for the MOP to be there and some degree of institutionalization to a greater extent than what exists right now is perhaps the need of the hour.
First of all, the Collegium system will need to be tweaked. I think the body will have to be enlarged. But the key test here is the ability of the people concerned to pick up the best, the brightest, and the most honorable people. And I really don't think that in a country of 130 crore people, we can't pick up a handful of such people. We can, provided there is a will to pick up the best people who while they may have certain views on certain issues, are fiercely known to be independent, are known to be people of great integrity. And look, integrity and ability and competence are known much before a person being considered to be appointed as a judge. The colleagues in the bar, the litigants, the people at large know about how good or deserving or undeserving a person is. So it should not be difficult for a body really to pick up the right kind of people. What is happening in the Collegium system is that many times one notices a kind of trade-off. Okay, you appoint so-and-so and we will support so-and-so. I've heard about this, and I don't want to go further on this, but this feeling or this perception, even if it is a perception, needs to begin to trust the appointment system. There's a lack of trust in the appointment system, and as I said, it is, and as the minister said, opaque at certain levels. So I think all the distinguished judges who constitute the Collegium, till such time as the Collegium system lasts, must consciously strive to pick the best and the brightest.
Thank you, Dr. Ashwini Kumar, for joining us on the broadcast, and always good to have you on the show with your views. Thank you so much. So you heard those two views. You had Justice Madan B. Lokar, one of the judges of the Supreme Court, who was on the bench of the NJC, who says that it's the government which is holding up the file. On the other side of the debate is the present, the Law Minister, and also what the likes of Mr. Ashwini Kumar are saying, that there needs to be more checks and balances when it comes to the top judicial appointments in this country. After all, it's the world's most powerful Supreme Court. Now, I'm taking that question to our guests as well who are joining us on the broadcast. Mr. C.P. Singh, who's the former Sessions Court judge, is joining us on the show. Mr. Kapil Sankhna, who's a senior lawyer, is also with us on the broadcast. And Mr. Deshratan Nigam, who's a political analyst, is also with us on the show. Kapil, I'm coming to you first. Do you agree with what the law minister has said? In fact, he makes certain very candid remarks and in fact open remarks about a coterie in the Supreme Court that seems to be running the bar and also the bench, allegedly.
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 Very well said. Very well placed. Let me put it like this. There are two aspects to it and both are very important. One is the history itself. Till 1973, what used to happen is that the government and the Chief Justice would appoint, there would be a consensus. And therefore, as rightly said by bylaws, as far as what is consultation, which has been stated in Article 124 was, that both the executive, the judiciary used to work together. Then came the first judge's case where they said consultation means consultation. The decision of the executives is sacrosanct, and then there were a lot of difficulties. This was overruled in the second judgment, and the second judge's case was very interesting. They overruled to say that they changed the meaning of consultation to concurrence, saying that it is binding on the President of India when the Chief Justice sends the name to honor those names. So the consultation was not concurrence after all. And this is where, as my lords rightly stated, the government started holding those files because it lacked the power to somehow impress upon the Chief Justice regarding certain names. And this is where the collegium system also came to be. Then, of course, came the third judge's case and NJAC, etc. We're not going to go there. But the difficulty that we face today is this, that we as a country, when we're talking about RTI, we're talking about openness, we're talking about transparency, there is a collegium system that's the best kept secret in the world. And you really don't know how and what is happening behind closed doors. And this does raise a lot of questions because you do know that there are certain families and the families are being promoted. And you really don't know what is the system.
And you know Kapil, that's not just a canard or a hypothesis which is being made. There is a very eminent researcher, Mr. Gadbois, who's done a fantastic research about where the judges of the Supreme Court and High Court really come from and what family and lineage they follow. That being said, I want to go to the other side of the argument. Mr. Deshratan Nigam. Yes, please, Mr. Sankhna. Yes, please go ahead.
This is very important. So to conclude what I was saying is the largest stakeholder are the people. I mean, that's there. That's obvious. They're being protected by the executive. I mean, that's there. Those are lawmakers. Then we're talking about the largest stakeholder who are affected are, of course, the judges. But you forget the third part of it. The third part of it is we lawyers who are in the court every day. And as Dr. Kumar rightly stated, we know the integrity, the honesty, the intellect of our brethren in the bar and the other judges who are being appointed. And therefore, when you really think about it, the largest stakeholder, the largest protector of the realm and the democracy and the laws are the lawyers.
Well,
and I think it's high time
you can't have a wonderful bench without a thriving bar. I mean, that's how it's said. I want to take that point to Mr. Deshratan Nigam. Mr. Nigam, while the law minister may have certain valid criticism, but if you look at the history of independent India, there was only, I think, 3 instances, but I'm going to talk about 2 because they're relevant here, where the supersession happened, which meant that the seniority of the judge was overlooked and there was somebody else who was appointed as the Chief Justice of India, Justice C.J.I. Ray, and Chief Justice of, Justice Khanna, who could not become the Chief Justice of India and had to lose to Justice Baig. That was the government of the day overstepping its limits and trying to make the judicial appointments political. Why shouldn't we have similar fears in today's day and age? Mr. Nigam.
Anusha, in fact, as everybody agrees, the original constitution as it stood had the word consultation. And by no stretch of imagination, consultation can become concurrence, be it any language. So that is overstepping their entire jurisdiction when they passed first judge's case, second judge's case, third judge's case and rejected the NJAC. And therefore, they forgot to apply the prime principle of the case is you cannot be a judge in your own case. The Supreme Court applying this principle on everybody else, but forgot to apply it on itself. So that is first argument. Secondly, something which is not in the structure of the Constitution, that collegium is not even mentioned, nor even a part of the structure of the Constitution. How can it become a basic structure of the Constitution? It has to exist, even obliquely it has to exist. To rule that it is a basic structure of the constitution, it's itself unconstitutional and
well,
illegal.
Justice Lokur said that 9 judges have said it, and you have to respect the judgment of the Supreme Court.
So if 9 judges say so, it does not become correct. Since they are saying so, therefore we have to follow. But Parliament can overrule that. It had happened in Shah Bano case also. New law came and Parliament can do it out of deferment and respect. They are not doing that. That is what the law minister said. And this is, as everybody agrees, that it's a very opaque system with a lot of nepotism. And as Ashwini Kumar clearly said, there is a paid-off. The perception of the common people is something different. So when you gave the examples, Anusha, of the three cases when they were bypassed and somebody else were appointed. But the people punished those government through the by way of elections. That particular government was removed from the office. So the final word lies with the people. If the elected government, which has the power and the duty and accountability to appoint judges, makes a wrong move, you can take them to the people's court.
Let me bring in Mr. C.P. Singh as well, who's been with us patiently on the broadcast. Mr. Singh, thank you so much for being a part of the show. You're somebody who's been part of the system. You're a former judge at the Sessions Court. Do you agree with the criticism of the law minister that there's a coterie which is running the top corridors of the judiciary of this country?
Certainly not. It has become a fashion to criticize the judiciary, particularly alleging that they are not honest, they are having groups, they are having nepotism. It has become a fashion in the concerned sections of the society, particularly those who have some interest in the law and courts. So far as the system of Collegium is concerned, people are saying that it is very opaque. I say no, it is not very much opaque. Nowadays, after recommendations are published on the website of the Supreme Court and High Court. Anybody who is having grievance against any person, he can go and challenge it. He can go and tell something about the candidate concerned that he is not a fit person. And Collegium is not recommending only the recommendation of the Chief Justice alone.
Yes.
The 5 judges of the Supreme Court, meaning thereby a body of 5 judges, a body of apex court of 5 judges recommending the case of a particular person. They know the best part of the judiciary, they know best part of the
Mr. Singh, you know,
the question about the person.
The question that
sometimes
I want to, the question I want to the question that I want to take to Mr. Sankla as well, and you know, the last 2 minutes each to our panelists. Mr. Sankla, let's talk about quote unquote executive interference in judicial appointment. It presumes that judicial appointments belong to Indian judiciary. I don't think I agree with that presumption. The executive role in judicial appointments across the democratic world is much more than what it is in India. Is there a case for greater executive role powers when it comes to judicial appointments, and can that in turn act as a check and balance? And I ask this to you as a respected member of the bar.
Well, I'll answer it like this. I will not say whether the interference of executive is required or not. I would definitely say this, that the involvement of all the stakeholders are involved. And I wouldn't be very biased when I say this, that lawyers really don't, the bar really doesn't have any say. And the bar should definitely have a say. And why it should have a say is because, as I said, we know what is happening truly, really, amongst ourselves, as far as other lawyers are concerned, judges are concerned, and the judiciary is concerned. So it is high time that when you're opening up the Collegium system, it's not just about executive interference. It is about involvement. It is about inclusiveness. It is about making
why
sure
are we wary of that involvement? Why, if you read the NJAC judgment, one of the fear is that what happened during emergency, how the Supreme Court was tinkered with, how the autonomy was affected. Why in today's day and age we are scared of executive being involved more?
Well, the difficulty here is that, you know, till something or the other happens, you tend to raise a lot of hullabaloo. I do understand that there have been at least 2 cases where there was over-interference of executive, but there could be certain checks that could be brought into place. I mean, just to say that because something happened at that time, it might happen again, and therefore we have a closed system, I think that's very unfair. And that's the argument that is also being made against RTI now.
Yeah.
Do we really want to give up our TI? No. I'm
Mr.
really proud of the fact that a thriving democracy, and it's actually become stronger, and people have more power now by the RTI and other such acts and powers that
Mr. Deshratna Nigam, I've last 1 minute, and this is the criticism I want you to answer. It is being said that when you have a strong elected government, like the present government, which enjoys the will of the people of this country, which represents the will of the people of this country, you need an independent judiciary to keep the government in check. And what has happened earlier is a lesson in history which the judiciary doesn't want to forget. It is not true, as Justice Lokur pointed out, that executive has no role. There is a reason why the law ministry is sitting on the files for a very long time, as the Collegium argues. Then asking for a greater role of the executive, is that something that we can learn from our history? Perhaps is an idea for which India is not ready for at this point in time?
Anusha, exceptions do not make a rule. If you look at the original intention of the Constituent Assembly, then I'm sure you would realize the entire discussion was on the prevalence of the will of the people. And will of the people is clearly reflected through a constitution where the executive has the power in consultation with the judiciary. That was and since they were accountable to the will of the people and they could be punished for their misdeeds. And here the collegium system is not answerable to the people.
Okay.
Where is the accountability? Where is the checks and balances? It is very opaque. You cannot challenge whatever they have said because you will not even know
Mr.
what is the
Nigam,
ground.
I agree with you on that point that however strong or sacrosanct an institution may be, you need checks and balances. Mr. C.P. Singh, Kapil Sankla, Mr. Deshratna Nigam, thank you gentlemen for joining us on the broadcast. We tried to put out this constructive debate in the larger spirit of reform, a reform that even the NJC judgment and all the 5 judges on that bench recognize is the need of the hour as far as collegium system is concerned. With that, it's a wrap. Ridhima joins you on the other side.
Good evening. Thanks a lot for staying with us here at CNN News 18. You're watching Plain Speak with me, Ridhima Bhatnagar. It's another day and another gruesome reality for all of us to face. The story that we're going to bring to you today should shock us all. Even if the post-outrage around the Nirbhaya case, if nothing has changed in the country, then there is really no return for us all. A kindergarten 4-year-old child was raped and sexually assaulted by the driver of the principal of the school she studied in Hyderabad. The child was allegedly raped over the last 2 months at this private school. The police have now registered a case under Section 376 Rape of IPC and the POCSO Act against this driver. But this wasn't just the reality in Hyderabad. In Ghaziabad, a 36-year-old woman was reportedly abducted by 5 men and then raped for 2 days. The victim now says she was assaulted by people she knew. The Delhi Commission for Women has taken cognizance of the incident. They've also sought a report. As per the SP of Ghaziabad, the victim was found lying on the ground in a sack and with her hands tied. She was then taken to a hospital. Her condition as of now is stable. 4 people have been arrested so far. The question is, where are things really going wrong on the ground? Is there no place as far as women in the country are concerned? I will take that question to our guests in just a bit. But first, I want to put out the gruesome details as far as the Hyderabad horror rape case is concerned. Just look at these details. A 4-year-old child was raped over 2 months. The child was raped by the kindergarten principal's driver, someone who had access not just to this particular child, but other students as well. The child was raped in a lab located opposite the principal's chamber. What was he really doing? That's a question that we'll try and get some answers to. As far